All right, well, good afternoon, everyone. Oh, that is a bit loud. Well, working now. Hopefully everyone here is for the talk from campaign to courtroom. If you're not, then you can't leave because I will cry. So thanks very much. We've got 45 minutes today. We're going to try and do it in about half an hour, 35 minutes. And then that's going to allow for questions that can be asked. I'm told to please do that through the Hoover app. Makes me feel very old, so I don't quite know what's going on with technology. But yeah, if you do have any questions, please ask them via that. And we can get to them at the end. Please do come in guys, and we'll just keep carrying on. But we'll start off by introducing ourselves. So Sam, if I can have the next slide, please.
Cool, thank you, Rob. Hello, everyone. Thank you so much for coming to our talk. I am Sam Magor, and I work in the Public Affairs team at Humane World for Animals UK. I have a bit of a cold today, so if I suddenly nod off or seem completely like I've lost my train of thought, then that might explain it. So bear with me, please. So what is this session about? So this talk is meant to give you a flavour of legal challenges that have been brought successfully and unsuccessfully to protect animals. We're going to be looking at a couple of cases today. One of them was successful and the other one was unsuccessful, and we'll be talking a little bit about why that was. We are talking about case law, so that might sound a little bit dry and technical to some of you, but we promise to keep the kind of technical detail and technical language to a minimum to not get too bogged down. And Rob.
Great. And my name is Rob Espin, so I am with UK Centre for Animal Law. I was with Humane World for Animals, but no longer am. That's why my name card is just a little bit off, but still work with the guys. In terms of what hopefully it won't be, hopefully it's not going to be dry. We're not just going to run through what different kind of animal laws are, because that's not really helpful to people. So we prefer to do it through a storytelling kind of style, because I think it's more interesting, and also hopefully gives people more review of what practical reality actually is of those real cases. And unfortunately, we also can't be all-inclusive. Like we said, we've only got 45 minutes, so we can't cover off every single case which has been brought for animals in the UK as much as we would love to, just because we don't have the time. So instead, we'd rather focus on 2 or 3 cases and really give you the depth and the detail of that. But fortunately, there have been other amazing sessions at VARC so far, already walking through them. So you might have been this morning to one by Lawyers for Animals, where they were talking about private prosecutions that Greta and Aisha spoke about. But those talks as well will give you more colour. But thankfully, we're not just the ones talking about legal cases today. So if we look at, in terms of what we're going to do very quickly, it is walking through those case studies. We're then going to talk about a little bit more other considerations. So if you're an animal advocate sat in a room and you do want to bring litigation or bolster your campaign through some kind of court challenge, how you should do that, and look at other things in terms of like costs, when you should do it, how you should do it in different ways. And then we're going to finish with some key takeaways of messages which hopefully everyone remembers if you can't remember everything else that I witter on about. And then we're going to finish with those Q&As we talked about earlier. But to start with, we're going to talk about one thing very recently, which you might all have seen, and Sam's going to talk to us about Oatly.
Cool, thanks, Rob. So I thought it would be helpful to start by taking a little step back to think about why this is important. So why are we talking about bringing litigation to help animals? So I thought I would start with a case that some of you, or lots of you, are probably familiar with, and this was the legal challenge that was brought against Oatly by Dairy UK. So this case started way back in 2021, and it finally concluded in February this year. And essentially what happened was Oatly wanted to trademark the phrase post-milk generation, and Dairy UK didn't like this. And they brought a legal challenge against Oatly saying that they weren't allowed to use the word milk because milk is used to designate an animal product or a dairy product. This was their interpretation of UK law, which is derived from EU law. Initially, when this case went to the High Court actually found in favour of Oatly and said that they were able to use the word milk, but the case was appealed and went to the Court of Appeal and then finished off in the Supreme Court this year. And unfortunately, both courts found in favour of Dairy UK, and they said that Oatly is not able to use the word milk on their products, which is why we've gone from oat milk to oat drink or other variations on different animal-based, oat milks. So this is obviously a really disappointing result for us. Generally, it has ramifications for vegan products as well, and also for Oatly. But I think it helps to signify why this is important and why we should be thinking also about ways that we can bring kind of clever, innovative, and timely legal challenges to protect animals rather than to harm them. So moving on to that, so we're going to be looking at 2 case studies today. Rob's going to be running us through them. One of them is a case where it was ultimately unsuccessful, and one of the reasons why we think it was unsuccessful was because there wasn't a strong kind of public mobilization or lobbying campaign backing it up. And then we're going to be looking at another case that was successful, and we think that one of the reasons it was successful is because it did have that strong campaign behind it. So Rob, back to you.
That's great. And the first one we're going to talk about is unfortunately the unsuccessful one, which is Chance Pixies against North Kesteven District Council back in 2017. Now, this one primarily concerned the breeding of dogs for commercial purposes, so essentially puppy farms and dog breeding farms to make money. The facts of the case of this, in 2016, North Kesteven District Council issued a couple of different licenses, 2 in particular, to 2 applicants who wanted to breed puppies and dogs commercially. And in order to do that, you have to get permission under something called the Breeding of Dogs Act 1973. Pause for a moment, the fact that the regulation of breeding of dogs in the UK is governed by a piece of law which is 50 years old, but welcome to the UK legal system for many different things. Chance Pixies are a charity which is focused on dog welfare and didn't want these licenses to be granted because they thought that the breeding of dogs and puppies in those conditions was not tantamount to prioritising their welfare, and these dogs could not be looked after properly. So they brought a challenge against the council, who was a relevant authority who had to go around and inspect and then issue these licenses to allow these puppies and dogs to be bred, to basically say that shouldn't be done and you've done it illegally. Now, in respect of one of the licenses at the start, the council actually conceded that it incorrectly done this. And the reason why was basically because of a procedural error. And what the council had done was the applicants had already started to breed puppies and dogs on their farm, and that's legal without the permissions. But when they went through the process to get a license, they backdated it to say, actually, the things that you were doing before, which is a regulated activity that you didn't have permission to do, we'll cover you off and say that's fine, even though you didn't get a license at the time. We'll just basically say, because you've done it now, it's fine. Chance Pixies challenged that, and the council admitted that that's illegal and they didn't have the ability to do that under the legislation, so they cancelled the licence. Unfortunately, however, due to the lack of local pressure campaigns, and that's not necessarily a criticism of advocates working in that field, but just a fact, the council was able just to straight away reissue the licences again and put the correct date on them to allow them to carry forward and do it moving forward. So again, you had these 2 puppy farms which were just breeding dogs on and puppies on a very large scale and doing that for commercial profit. Chance Pixies didn't give up, however, so they carried on to challenging that. Have we gone off? No, yeah, it's a sign, isn't it? Hurry up. They basically brought challenges to say that actually, even if they've procedurally gone through the correct process this time, what they've done was illegal, and that was on 2 factors. The first one is that when the inspectors from the local authority went round with veterinary professionals who said that, yeah, these places hit the requirements of the Breeding of Dogs Act to allow them to breed these dogs, they didn't go through something clause by clause called the Code of Practice for the Welfare of Dogs, which is something under the Animal Welfare Act, which is supposed to make sure that people properly look after their dogs by following the requirements of this Code of Practice. They also said that essentially the council had fished for opinions, because a first veterinary inspector who went round to one of the farms actually looked at the ways in which the dogs were exercised and said, you're not exercising these dogs properly, you're not allowing them to run outside, you're allowing a couple of dogs to go outside and have some space and time, but the rest of them are just stuck indoors in this massive barnyard the whole time. That veterinary inspector, doing their job as properly as they could, got into a bit of a conflict with the farmer, and therefore they requested another opinion from another veterinary inspector who disagreed with the first veterinary inspector who went round and said that the dogs were being exercised fine, and that was all done properly. So this ended up in the High Court of England and Wales in 2017, and unfortunately Chance Pixies lost on both grounds. On the veterinary inspector point, it was essentially said that the District Council could rely on the most recent report, and it was up to them to choose which one was done. So unless there was some manifest bias which had kind of been shown, or incorrect procedure in picking which veterinary expert had gone through, it was fine for them to look at a later report, even if there was an earlier report which contradicted that and said that these dogs weren't being looked after properly. And on the first point, in respect of a code of practice, now despite the fact that this code of practice blatantly applies to everyone who keeps dogs in at least England for any kind of purposes whatsoever, be it as a companion animal, but also as well in respect of commercial practice, the Breeding of Dogs Act 1973 does not say in black letters that the inspectors, when they go around, have to make sure that every single part of that code of practice is being complied with. Instead, there's a more higher level set of factors which applicants who want to commercially breed puppies and dogs have to go through, and they only have to make sure that those are complied with, not the more detailed parts of the code of practice. So on that basis, the judge basically said, well, the law doesn't say that you have to comply with this thing, therefore, even though the inspectors didn't look at the fact that this isn't being complied with, it's fine, and it carried on. That meant that these licenses continued in force, so the applicants under them could continue breeding dogs for a period of a couple of years at least. And the takeaway for the campaign point of this as well is that even though the licenses were withdrawn by the council at the start because they basically messed about trying to authorise stuff on a backdated basis where they weren't actually allowed to do that, there wasn't sufficient grassroots pressure on them to then say, don't now reissue these, because there's also welfare issues with these applicants who want to breed puppies and dogs. So that result, unfortunately, was a loss, and it was a while ago, but those farms may still be breeding puppies as we speak. So now if we go to a bit more of hopefully a positive case study, and this one is in Scotland and is a different case, moving away from, I guess, the farming of animals, but the farming of companion animals. It's talking about wildlife. So this one is Trees for Life and Nature Scot in 2021. Full disclosure, I was heavily involved in this one, so if it makes that sound like it's more positive than it is, then you can blame that on my personal bias. There's also a picture of me on the screen as well when the case result came out. So this was in respect of Eurasian beavers, particularly, which I'm sure everyone's kind of seen about in the press as the kind of modern darling of everyone's favourite endangered species, which has been reduced to the country. But up until 2009, beavers were actually extinct in the UK. They were originally a native species and very, very prevalent, but due to, of course, as always, human persecution, we'd basically wiped them out. Then following some very illegal unofficial reintroductions, Scotland actually brought about their own scheme of official reintroductions of beavers throughout different areas on a pilot basis at first, but then continued to roll them out on more of a national basis. This culminated in 2019 with beavers actually being given enhanced protection as a basically European protected species. So they had more protections against persecution than other wildlife in Scotland, and the same regimes apply for in England and Wales as well. Now, as these beavers were being reintroduced everywhere, unfortunately, as we all know, when human and wildlife interests come together, there's often conflict. And many different forms of landowners were basically complaining about the fact that these beavers were coming close to their land in different forms, be it agriculture or different types of property, and allegedly posing risks to this, and they were damaging it in different ways. And under the relevant Scottish regime, which is basically the Conservation of Species and Habitats regulations, whilst beavers are quite heavily protected, you can't kill them, you can't disrupt their habitat, you can't disturb them in different ways. You can if you apply for and get a licence from the relevant regulator, which in Scotland is Nature Scot. So what was happening was we had protected species of beavers who were going around doing their beavery things, building dams and cutting down trees and making the environment a lot better and more natural, as they should do. But landowners were not happy about this because they were saying it's causing risks to their property, their crops, agriculture, whatever was happening. So they were applying for licenses from Nature Scot to basically deal or manage, in inverted commas, with these beavers. What Nature Scot were doing was looking at these cases and then considering them against the requirements of the legislation to see what you had to do in order to grant licenses to manage beaver-human interactions, let's call them that. What they were doing is, in many cases, they were granting these licenses, and what they were permitting was not just, okay, see what you can do to resolve the issue with the beavers incrementally, look at building fences, or maybe moving their dams elsewhere, or maybe moving the beavers themselves. What they were basically licensing was a shoot-on-site policy of if you have issues with beavers, you can just go to the the nuclear resolution, as it were, and you can just kill them. That was on a basis of it was being done for hundreds of licenses by many different applicants, almost on a presumed basis of if you have very nice prime agricultural lands, but there's beavers in the rivers near you, we'll give you a license to go out and shoot them. Trees for Life is a Scottish conservation charity which, together with various different animal advocates from different types of Scottish law firms, English law firms, and NGOs, wanted to challenge this on the basis of the fact that you can just kill animals on a assumed basis is completely wrong. So essentially with Trees for Life, we brought together various different arguments, but they came down to probably one very important substantial one and one less seemingly important procedural one, but we'll come to that in a bit. The first one was that when you go for licensing of managing with endangered species, it shouldn't be the case that you can just go, okay, first thing you can do is shoot them. You should actually look at whatever the issue is that's going on, and actually you should then prescribe action which is proportionate to that issue. So if you could deal with the issue by just putting up fences or moving them away, that's what you should do. Other arguments were also brought in that as well in respect of looking at the fact that if you just bring out mass culling of beavers, you affect the genetic diversity of the species on a local population level. Part of the legislation means that licensed actions cannot be taken against animals where that could have a detrimental effect to the positive conservation status of that species. So by just basically permitting mass culling, you're wiping out the genetic diversity. Many different other arguments were brought. We relied on case law from the European Union at the time, looking at the management of wolves in different Scandinavian countries and Eastern European countries, because that was a time when EU law was still very relevant in the UK before the great victory, in inverted commas, that was Brexit. And then we brought all those things, but one of the other arguments we kind of tucked in at the end was that when these licenses were issued, they didn't have reasons of why Nature Scott had granted them. I mean, the reasons were obvious to a certain extent. It's that people didn't want beavers anywhere near their land. Therefore, they were permitting people or people that they were authorised to go out there with rifles and shoot them. But they were supposed to give reasons of why they'd done this. And for the hundreds of licenses that we saw over a couple of year period of bringing requests under environmental information, freedom of information requests, we could see that they'd never done this. So we put that on the end and basically said, oh yeah, also you haven't done the licenses properly because you didn't give reasons. We got to the High Court in Scotland, made all our arguments. And unfortunately on every single one where we looked at actually the protection of the species itself, we lost. So the court actually thought that if they wanted to, it was up to Nature Scott to basically license the most lethal form of management in the first aspect instead of going through a waterfall of solutions that could come through. We disagreed with that, but that was the opinion taken at the time. They also didn't agree with our genetic diversity arguments. They didn't look at the other kind of cases we tried to bring into it. But what they fortunately did look at was the fact that Nature Scott didn't actually put any reasons on the licenses. And that's a black letter requirement which they had to do, and they hadn't done it for hundreds of these licenses. So they basically looked at them and went, yeah, all of these are illegal, you're gonna have to reissue them all, and struck them all out. So straight away on a technical background, we won because we looked at what they were required to do and have that transparency of information of why they are doing these things, and they hadn't complied with it. And therefore the High Court said, no, you've not done your job properly, you had to go and do them all. Now the differentiation between this and the Chance Pictures case is that no, I guess, credit to us involved in this, but because of the campaigners from a conservation aspect and from a wildlife aspect in Scotland, there was massive pressure on Nature Scott not to go out and reissue these licenses again. In fact, when we were actually bringing the case, every single week we put in freedom of information requests to see how these licenses were being granted and get everything from it, to see the emails that were going through. We saw even like chat room activity where the licensing authority was being given to like summer graduates on internships, and they were basically saying, go and do this as your work experience thing, go and permit people to go and kill these endangered species, which was very scary. But as through that process and the pressure campaign, we saw a marked change in the approach of basically Nature Scott representing the Scottish government, in that they stopped doing that. So you had cases instead where beavers were maybe actually posing a risk with their work and their digging and the stuff they do with rivers to roads and other structures. But instead of Nature Scott going, oh, we'll just go out there and shoot them and it's fine. Instead, what they were doing was going, okay, get someone out there to inspect it, get someone out there to try and move them, look at fencing, try and take away the dams. And that was from the campaign that was going alongside it, which at the same time meant that when it came to court, many of the licenses never got issued again. So that basically saw a lovely dovetail between litigation being brought strategically, but also campaigning of people looking at bringing public affairs through at policy level, and also in grassroots to make sure that these animals were properly protected.
Oh, great. Sorry, that we're about 2/3 of the way through the talk. Thanks for the clap, everyone. So yeah, thanks Rob for giving us the detail on those cases. So just to zoom out a bit now and talk a little bit about bringing challenges against government specifically and kind of judicial review challenges. So when we're thinking about judicial reviews, a helpful distinction that we can draw is between challenging the substance of the law or a decision the government has made, and also challenging a procedural point. And this was brought out nicely by Rob in the second case he discussed there. So this can be seen as the distinction between the what, or the substance, and the why, or the how, which is the procedure. So substance is the kind of content of the law or a decision that the government has made. And as an example, we can think about the welfare of farmed animals regulations, which permit keeping pigs in farrowing crates when they give birth. So this is kind of based on the government's assessment of veterinary and scientific evidence, and their belief that keeping pigs in farrowing crates is consistent with obligations under the Animal Welfare Act. For example, obligations to make sure that animals have a suitable environment and that they are spared unnecessary suffering. We would contend that. We would say that that's not true. And as an aside, hopefully this is going to change soon, because the government is consulting on phasing out farrowing crates. But that point of substance is, the fact that pigs are currently kept in farrowing crates. Then you have procedural challenges, which is challenging the procedure by which a law or decision was made. Examples are things like the government not consulting properly on a decision, so perhaps they didn't consult for long enough, or perhaps they presented a foregone conclusion in the consultation, which meant that it wasn't really possible to get them to arrive at a different conclusion. Or we can bring challenges against planning applications. So if a local authority, for example, issues the wrong environmental permits, or perhaps doesn't take into account what we might think of as relevant factors, for example, animal welfare or water pollution or air pollution, things like that. So in recent years, the courts have been much more inclined to find against the government on points of procedure than they have on points of substance. And this is probably for a few different reasons. One of the reasons is that I think courts they have a nervousness about weighing in on issues that they deem to sit within the wheelhouse of the government. There is probably also a nervousness around the kind of significant widespread implications that there could be if the court was to find in favour of us, of the movement, on some of these things. For example, if a legal challenge was brought to do with the fact that pigs are currently being kept in farrowing crates, if the court was to decide that is unlawful under the Animal Welfare Act, overnight the pig industry has a massive problem, because we have loads of pigs being kept in farrowing crates, and that would suddenly be, legally unstable. The government and the pig industry would need to do something about that. So there are probably a few reasons why courts are currently nervous to weigh in on substantive points. Yeah, procedural cases are more likely to win, but that's definitely not to dissuade or totally dissuade people from bringing challenges based on substance, because those cases can be really helpful for other reasons, even if they don't win. So, for example, the judgment might include an interpretation of an aspect of the law which is helpful for us and enables us to bring further cases in future to advance the argument. Also, legal challenges almost always attract good media attention, and this can help us to build public awareness on an issue. Also, when you challenge the government on an issue, it forces them to consider the law, consider their practices, and also defend their position publicly. So that can also help to shift the dial on these issues. So I suppose the broader point is that progress in the movement isn't linear, and we don't always know what the long-term impact is going to be of decisions and actions that we take now. So even when a case fails or isn't successful now, that doesn't mean it won't have contributed in the long term to advancing protection for animals.
Thanks, Sam. So we want to not finish, but round up towards the end with some more practical considerations of if people are animal advocates who sat in a room who are thinking about bringing cases, what you should consider, and running through at least 3 of the main ones. So the first one is costs. And this isn't to scare people to act as a barrier of bringing things, but unfortunately lawyers do cost money, sadly. Maybe sometimes they should and they shouldn't. But it's about thinking about how you're going to satisfy basically paying for a legal challenge if you want to do this alongside your campaign, because campaigns obviously aren't cheap either. Now, this can be done in many ways. In fact, if you're bringing certain types of cases, you can actually apply for something called a cost capping order. Now, this is easier for environmental cases. So if you're looking at things like wildlife conservation or protection, or indeed maybe you're using environmental regulations in respect of factory farming and using it as a weapon. Under that, there's set precedent which basically says that you can get, in many instances, something called a cost capping order, which normally fixes the costs of the claimant of around £10,000, which still sounds quite a lot of money when you think about it. But if you compare it to the massive amounts of money which can be spent on lawyers, both sides, and you can be liable for if you lose, makes it much more sustainable. And when presented with, a legal infrastructure which is intimidating, with lots of challenges to it, trying to find where the money is going to come from, thinking about doing it in creative ways. So can you collaborate with other organisations to share the cost of doing this together? Because it's not always just a financial perspective. Sometimes it's also the human cost of finding the time and the energy for people to do it. But also looking at other ways to raise money. So for example, crowdfunding. In respect of the Trees for Life case, that was completely crowdfunded. And we actually were successful to a point where we raised more money than what was needed. And that extra money went back to other charities that were working on environmental and animal protections in Scotland. And people don't necessarily think about that kind of thing. And also costs are quite proportionate to the level of challenge that you're bringing. So for the Trees for Life case, obviously we're challenging the Scottish government over something on a national level, so it cost the amount that it did. But if you're bringing claims against maybe your local authority for licensing something like, I don't know, donkey rides on the beach where you don't think that should be done, or for pet shops, the cost should be proportionately a lot smaller because of the issues which are involved. The next one is impact on policy making. Again, this is more focus on timing, because people are stretched, local authorities are stretched, DEFRA, Natural England, Natural Resources Wales, DERA are all stretched in respect to the people who are working on animal protection issues, both from a policy perspective and a licensing enforcement perspective. If you sue them, often they're the other people, the other side of a table, that if you have like another campaign or you want to engage with local stakeholders who will be talking to you about the same kind of issue. That's not to say don't do it. It's to say maybe think about the timing in respect of when you bring litigation in respect of your campaign. So let's say you have a massively successful campaign and things are changing and you're months away from the change that you want to see for animals being implemented. Maybe don't sue them, because they're not going to be your best mates. But if you've been working on the issue for years and you've got no headway and you don't know anyone or things like that, then actually using that as a Kickstarter is much more powerful. And finally is on types of claims. So actually looking at getting creative, what you can do. We've looked at judicial review mainly today, which is a very formal perspective, but looking at things a bit more widely. So actually, what have we got in respect of different avenues for bringing claims? I've already talked about private prosecutions and the talk that Lawyers for Animals did earlier as well, but things like looking at advertising laws and consumer trading laws. So if you've got things where people are humane washing or saying things are better than animals than they actually are in the media, either at a local or national level, trying to use those laws creatively to actually bring them to account and hold them to justice.
Just to really, really quickly wrap up, so 3 key takeaways from us. So, achieving change for animals is really, really hard, and we need to use all the tools in our toolkit in order to do that. So we're just inviting people to think about opportunities where it might be possible to bolster a campaign that's running with some strategic, timely and well-considered litigation, but also to make sure that any litigation that is brought is backed up by a campaign that means that any wins that are achieved aren't kind of backtracked on immediately. Procedural cases are more likely to win as things stand in the courts, but that's not to dissuade people from bringing substantive cases, because they can have other benefits. For example, bringing media attention to something, public attention, and also forcing the government to kind of show their hand and keep those issues on the radar. That is it from us. Welcome any questions. Thank you so much.